Good morning. Good morning, everyone. I'm Jessica Walker, the president of the Manhattan Chamber of Commerce. Thanks for joining us. This is a very timely topic. As you know, just last week we had the Supreme Court ruling striking down the tariffs, and today we want to explore what that means. Obviously, there's still a lot of uncertainty about if the tariffs are going to continue in some other form, which we can discuss a little bit today. But really, the key topic that I'm hearing most about is who's going to be able to get refunds? Are we going to get a refund? And if so, how do we go about it? And that brings us to this discussion. So, of course, we sought out the expertise of Siddartha Rao, who has been doing excellent work in this area. I've been reading all of his briefings because there's so much changes day to day, and it really has been very helpful. So I wanted to share this resource with all of you, and I will now turn it over to him.
Jessica, thank you so much for having me. And it's such a thrill to hear that my briefings are being read and that they're helping people. So, yes, I intend to talk about everything Jessica spoke about. Just very quickly, who I am, I'm a partner at Hoguet, Newman, Regal, and Kenney. I'm admitted to practice in the Court of International Trade. As Jessica mentioned, I author a blog. We have a blog called Tariff Tactics. I've litigated Administrative Procedure Act tariff challenges, obviously working in the IEEPA refund space, and for better or worse have been quoted in some news stories about this issue. So here's how I've sort of structured the roadmap today. I do want to be as helpful to importers as possible, but there are probably different questions that different people have. So I'm trying to kind of give something to everybody here. The first issue is just very brief, is why there has not been any specific addressing of remedies or refund process. The second, which I really thought maybe not to put in, but I think it's important, we are going to parse the Supreme Court decision. It's not to go into constitutional theory land. It's because it's directly relevant to how new tariff imposition is likely to play out, both at the administrative level and in the courts. And I think that the take that I'm going to give you is not one that you may have seen sort of generally reported. So I'd like to just parse that out. Then we're going to talk about what I suspect a lot of people want to know, which is how do you get the refunds? What's the process, the timing? We're going to discuss two ways that could play out, some practical guidance, issues around the new tariff imposition, and then conclusion and Q&A. So with that, starting with the remedies issue, and I think you don't need me to tell you this, but I'm going to start here. The Supreme Court did not address refunds. So there was 170 pages of, majority, concurrence, and dissent opinions, several opinions. The word refund, I think I counted it 4 times, and it's mostly in Justice Kavanaugh's dissent. There was no directive to Customs and Border Protection to issue refunds, nothing about retroactive relief that had come up in the oral argument. And just to be clear, that's a good thing. In oral argument, there was some speculation that maybe the court could order only future relief, but it seems like that's not what they did. There was no discussion of the sort of nitty-gritty of how tariff refunds actually work, liquidation status, equities, administrative exhaustion. So pretty much not a lot to go on there. And then, as we all know, the administration has itself not really addressed the refund process. On February 23rd, Customs and Border Protection issued what's called a CSMS, Cargo Systems Messaging Service Announcement, and essentially said, we will not collect IEEPA tariffs going forward. So they're no longer assessing IEEPA tariffs at the time of importation. Those are not getting included in tariff entries. But notably, this CSMS announcement didn't address if, when, or how the IEEPA refunds would be issued. And there were also some statements by White House officials essentially saying, you got to go to court to figure this out. So from what I can tell, and from what we can glean from all this, it doesn't seem like the executive agency, the Customs and Border Protection, is actually going to do anything until ordered by the Court of International Trade, which will obviously be significant for how importers manage this process. Okay, this is the part where we're parsing the decision, and I'm going to be quick about it. First of all, why didn't the court address remedies? One obvious answer is minimalism. They want to decide a case by deciding the fewest issues possible. And in oral argument, everyone agreed, the government and the claimants, that Article 1 gives Congress the power to tax and that the power to impose tariffs is part of the taxing power. That was conceded by the Solicitor General. So those were not really issues that really needed to be gotten into since that was agreed. The only issue then left was, does IEEPA authorize the president? Did Congress delegate its taxing tariff power to the president via IEEPA? There's also institutionalism issues, and Chief Justice Roberts is known to be an institutionalist. There were very institutional leaning statements, especially in the latter part of his decision. And part of the reason he didn't get to the remedies is that was one of the arguments the government advanced for keeping the tariffs in place, just that it would be, quote unquote, a mess to have remedies. And so I think Justice Roberts he wanted a decision that was on the law and not a decision that was about whether this was practically or how it would be practically enforced. And then, of course, typically remedies do get addressed by lower courts, so that's not a big surprise. Okay, now getting into the decision, this is an outline of the majority decision. Justice Roberts wrote an opinion, but it wasn't the majority opinion because he's joined by 5 of his colleagues only as to certain parts of the decision. So that's what is the majority, not the entirety of Roberts' decision. The first part is just the background procedural history. Everyone agreed on that. The second says, look, Congress has the taxing power. Quoting Hamilton, it's the most important of the authorities. Framers gave Congress alone that power. The government essentially concedes that there's no peacetime authority to impose tariffs. And as Robert says, the United States is not at war with, quote, every nation in the world. So that's his sort of laying the groundwork. Then he says on statutory grounds, IEEPA doesn't explicitly say tariff. And other statutes do say tariff. So it's unclear why this one would include, why Congress, if they had intended to grant tariff authority, wouldn't have said tariff. What it does say is you can regulate importation or exportation. And Roberts makes an interesting point, which is if you read the word regulate to mean tax, then you violate the Constitution because it says that you can't tax exports. So that's so far the majority. And this part of Roberts' opinion is where it starts to split. This is the major questions doctrine, and this will be relevant to future tariffs. So here, there's only 3 justices that join Roberts. And essentially, Roberts is saying, we don't like to read into an ambiguous statute huge delegations of power that are core to the legislative branch. He also points out that no president has ever invoked IEEPA to impose tariffs in 50 years. And he concludes by saying you need clear congressional authorization, and then this institutionalist statement that we're not economists, we're not finance experts, we're just judges, and judicially we can't find support for a tariff power in IEEPA. That's the second part of Roberts' decision that is non-majority. Now you have this concurrence by Gorsuch, which is a ringing defense of major questions, and I have hinted that this will be relevant for future tariffs, and I will definitely tie this all up. Gorsuch says the statutory analysis is not enough. You do need to use major questions. He pretty much accuses Sotomayor and Kagan, and to some extent Justice Jackson, of inconsistency. He said, in the COVID context, you read statutory grants very broadly. Now you seem to be reading this regulating imports narrowly. He says Justice Barrett is wrong to try and dodge major questions, criticizes the dissent for great inflation, to try and make IEEPA support tariffs. And then he says, look, the dissent says that the president has foreign affairs authority. So if he has foreign affairs authority, he doesn't even need delegation from Congress. And he points out that that would swallow up too many legislative functions. Finally, Justice Thomas wrote a sort of an odd dissent saying that Congress can delegate pretty much anything to the president forever. We'll get to that. And Gorsuch says, no, that can't be. Barrett, as I mentioned earlier, tried to argue that major questions is really just sort of common sense textualism. It's just textualism with the context of constitutional core powers. And she says, If the Constitution permits Congress to give the executive power, who are we to get in the way? Kagan wrote a short concurrence saying, quote, straight up statutory construction resolves this case for me. She didn't want to get to major questions. Jackson wrote her own concurrence where she essentially said, yeah, statutory construction does it, but in case it doesn't, look at the legislative history. Quote, why would it matter which interpretation we think is best when Congress has already told us? Now you have Thomas's 18-page dissent. Justice Thomas basically said, yeah, core legislative powers must be clearly delegated to the president, but core legislative powers only arises in terms of deprivations of life, liberty, or property, and everything else can be delegated without sort of clear delegation because it's non-core. I bring this up because Justice Thomas, his dissents can often be prophetic for sort of where the court goes on issues. I think this one was way out there, and personally, I just don't see this as guiding future decisions, but it's notable. And finally, Kavanaugh writing for dissent, and I'll note his 63-page dissent is 3 times the length of Roberts' opinion for the court. And Kavanaugh basically gives 2 statutory reasons. He says, no, IEEPA does give the authority and regulate imports as historically encompassed tariff powers. As much as I don't like the result, I actually think Kavanaugh's argument is very compelling here. And then he says, look, the president has foreign affairs authority, so you don't even need to get to delegation and major questions. The last thing he says is the refunds are likely to be a mess. So, let's not go there. And then this is very important. He argues the president can impose tariffs through other means. And he practically gives a roadmap for that. He goes through every statute and how it could be done. And note that this dissent is joined by 2 other justices, which means 3 of the justices will support any of these reimposition proposals, as long as they follow the roadmap that's in the dissent. So what was reported as a 6-3, 6 justices voted to invalidate IEEPA tariffs, 3 upheld, is actually a 3-3-3 split on doctrine. And this is relevant. And this is where I'm going to tie it all together. 3 of them think major questions governs, but Justice Barrett is not even sure that major questions is a real impediment to administrative action. 3 think it's just statutory interpretation, no major questions. And Justice Jackson's willing to throw in legislative history on top of that. And then the dissent says, no, regulated importation means tariff, but also there's this huge roadmap for tariff reimplementation. And then we have Justice Thomas who says you can delegate anything but life, liberty, and property. So let's think about new tariffs. I mean, we have these 122 tariffs now, and I'm going to circle back to that. There are already rumblings that maybe they're not legal, they're invalid. If you look at this, I'm going to go back 3-3-3 model. 3 of the justices are going to use major questions doctrine to interpret any tariffing statute. But Barrett might not actually think major questions really stops the administration. So it's kind of like 2, excuse me, it's like 2.5, let's say. Pure statutory interpretation, especially with these other tariffs, is not going to really constrain anything because those statutes do talk about tariffing authority. There could be other commitments that this liberal bloc doesn't like major questions, but they might nonetheless push back on sort of structural, the executive legislative structure of branch powers, but their doctrine at least doesn't clearly constrain tariffs. And then the dissent gives pretty much broad tariff reimposition. The last thing I'll say is because IEEPA refunds will have to be paid, and it's a lot of money, there is a sense that the administration might need tariff reimposition simply to raise revenue for the refunds. So I think we're going to see pretty aggressive tariff reimposition. And with this framework, I think we can actually predict more clearly that what seemed like a Supreme Court repudiation of some executive tariffing authority is much more complex and might not play out that way. Okay, so now I'm going to shift to what I think is more relevant in the immediate short term for importers, which is what do I do? That's what the Supreme Court said. That's great, but they haven't told me anything about remedies. The government hasn't told me anything about remedies. So I want to just frame this more generally, and then we can drill down to specifics. So first point I'll make is the only entity that can actually refund tariffs is Customs and Border Protection. It's not the Court of International Trade. This is unlike your typical litigation where a judge will order a party to pay a certain amount of money to another party, typical commercial litigation. The CIT is never going to order Customs and Border Protection, hypothetically, to pay $1 million to some claimant. What they can do is order Customs and Border Protection to create a refund process. So you're really dealing with two things here. You're dealing with process questions, which go to the CIT, and then refund questions, which go through Customs and Border Protection. So I think that what's going to happen is pretty much similar to what happened in United States versus US Shoe Corp. I will caveat that by saying United States versus US Shoe is a 1990s case, and we're in a totally different world today. And I don't really want to derail this whole talk by talking about broader themes of the rise of nationalism, sort of breakdown of free trade agreements, and sort of geopolitical things. But clearly the world we live in 2026 is not the world we lived in when, I think this was Justice Sandra Day O'Connor wrote for the court in US Shoe Corp. But nonetheless, I do believe this is instructive from a process level. So in US Shoe Corp, there was a federal harbor maintenance tax. The Supreme Court held that it was unconstitutional, which then required roughly $730 million of refunds to be issued to a whole slew of exporters. As with this case, the Supreme Court did not enter into discussions of remedies. What actually happened is exporters sued en masse in the Court of International Trade, and Judge Jane Rustani established very competently and very intelligently, I may add, a procedure for exporters to resolve the claims with Customs and Border Protection, with judicial oversight. It took 2 years, but the refunds were ultimately processed. I'm going to say this. I've been talking to importers since going back to the oral arguments, and it's not just to sort of like push people to litigation. I've mostly told people not to file lawsuits until now. Now I think you should consider litigation because if this process unfolds as it did in US Shoe Corp, that puts you in the space or the set of claimants before the Court of International Trade who will then be funneled into a refund process. To be very clear, I'm not saying that you can't go to the Customs and Border Protection now. I'm just saying that any refund process that emerges is probably going to be mediated through the Court of International Trade. So I do think importers should strongly consider engaging with the Court of International Trade. Okay, let's talk about that. Some large companies have already filed. Costco very publicly filed in December. FedEx filed, I think, last week or this week. I think on Monday. FedEx filed on Monday, right after the court decision. So why? Why did they do that? Besides the reasons I just gave, the Court of International Trade can take, so when tariffs are assessed, they're assessed, as some of you may know, through entries. And entries govern tariff assessment in the following way. An import comes in, and then data is submitted to Customs and Border Protection about the goods, the classification, the value of the goods, the various tariffs that might be applicable based on country of origin, classification, and value. All of that is then computed into an estimated tariff owed and is turned into what we call an entry. Dealing with Customs and Border Protection can sometimes be an entry-by-entry contesting process. Whereas with the Court of International Trade, they can deal with all entries more efficiently as a group. I've talked about liquidation a couple times. For those who don't know what liquidation is, it's two things. It's the point where Customs and Border Protection sort of finalizes what was previously an estimate. So at first they estimate your tariff payment, you make the payment, but ultimately they have to liquidate, that is, finalize it. And when they fix it, either you get a little bit of money back or you pay a little bit more, but you basically take what was an estimate and turn it into the real amount. That's liquidation. Liquidation is also a procedural event because it governs the remedies you can exercise. Once an entry is liquidated, you really cannot challenge through the, prior to IEEPA and the Supreme Court decision, it sort of cut off your ability to bring court challenges. You were limited to what are called administrative protests, and you had 6 months to file protests. And you could only really go back to court if CBP denied the protest, to have the court review the denial. So liquidation was a procedurally significant event. What's happened in the lead up to the IEEPA litigation is the AGS case, where the Court of International Trade, partly to sort of calm everybody down, said, listen, we can order reliquidation. So wait, don't file your cases now. When it happens and when the Supreme Court decides, we can reopen it and reliquidate entries. That's what FedEx is asking the court to do. So we'll just look at that quickly. They filed on February 23rd. This is the relief they want. They want the Court of International Trade to order Customs and Border Protection to reliquidate, meaning if entries have already liquidated, open them up. So that's what they say. Anything that has been liquidated, sorry, I think I should say reopen liquidation for any entries that have been liquidated. Then take all of those now unliquidated entries and liquidate them, but take the IEEPA component out. So you're turning a fixed amount to an estimate, and then you're turning it back into a fixed number, but this time you're taking IEEPA out of the calculation, and then order Customs and Border Protection to refund. And of course, FedEx asks for attorney's fees and costs and such other and further relief as the court may feel is just and proper. Now, notably, FedEx doesn't say how much money it is. They don't say which entries they are. They're dealing with this in bulk, which means they're not breaking up entries that might be liquidated or might be protestable or might not be protestable or might have pre-liquidation. They're not doing that analysis. That's probably a business decision because that analysis takes time and coordination across a lot of trade finance and other departments. And for FedEx, we can presume has fairly large IEEPA tariff refund exposure. They prefer to do this in bulk, which means they're opting for speed. They're first in line. Where I'm going to get to with this is they're probably foregoing the award of interest on their IEEPA payments, but speed matters more, I suspect, here than getting the most amount of money. Okay, so we talked about liquidation. I'm just going to run through this in a little bit more detail. After there's a tariff entry, liquidation is typically scheduled 314 days. Historically, Customs and Border Protection could extend liquidation deadlines for good cause. In the IEEPA context, there's, Costco alleged that they asked and CBP refused. Today, an importer could ask to extend liquidation deadlines to do sort of a wait and see. I don't recommend that, but you could. That is an option if your entries have not yet liquidated. There's also something called post-summary correction of an entry, which you can do either before the earlier of 300 days of entry or 15 days before liquidation. So that's like a pre-liquidation remedy, but it's really to correct data that might have been just mistakenly submitted into what's called the ACE system. It's not a very broad remedy. And because it's limited to correcting entry summary data, I suspect that it's not going to be relevant to IEEPA refunds, though I don't know that for a fact. So I don't really recommend this, but it is an optional tool if you are, for some reason, more interested in dealing with Customs and Border Protection than with the court. Now, after liquidation, there are these administrative remedies. You can file a protest. It's actually very simple. It's a simple form, and you have 6 months to do that. Some importers might want to consider this, though I am recommending going to court. Here are the advantages of filing a protest. You file a protest. If it's denied, you then get a right of judicial review. And interestingly, because this is under a different jurisdictional statute, you get interest payment. So maybe that is of relevance to some importers. It probably takes longer, and my instinct is that for most people, speed will matter more than maximum recovery, but it's something to think about. There are also more complicated tariff strategies where you might strategically want to keep certain entries liquidated or unliquidated. For example, something called a duty drawback, where you import, but then you immediately export, and there's a netting out of tariffs because you sell. It's complicated and it's kind of outside the scope of this talk, but I am seeing clients where this question of should we go to the court or the CBP is partly driven by their duty drawback strategies. Okay, if you wait 6 months after liquidation, it's called final liquidation. There's no administrative protest. If there's any relief to be had, it's not from Customs and Border Protection, it's from the court. Okay, so whether you go to the CIT or CBP, these are the things you should be doing. Preparing documentation, then assessing your court versus administrative routes, contractual impacts, and replacement tariff exposure. We're going to go through each of these. So this is a little mini roadmap of what's to come. Documentation. Something that probably all of you know, but some people don't know, is that tariffs can be stacked, meaning the same import could trigger multiple tariffs. And that means that the IEEPA tariff can be just one part of the total tariff or duty that's paid. And so the refund will only partially apply to the tariff paid. It's only going to apply to the IEEPA component, which means you need documentation of the IEEPA component. Now, the good news is all of this tariff entry data is submitted into something called the Automated Commercial Environment. It's ACE. If you have a customs broker, they are submitting entry data through ACE. Customs and Border Protection can also see entry data in ACE. So everyone kind of has a shared set of data, which makes this process quite a bit more efficient than it would otherwise be. You could probably just export your data from ACE, and it's definitely there if you pay tariffs. So for those of you who are wondering about documentation, but maybe aren't the frontline person dealing with your customs broker, this is not as complicated as it seems. That data should include at minimum the number, date of entry, date of liquidation status, description of the merchandise, records of tariff payment, that sort of stuff. And I've noted here, if you work with a customs broker, get the records from them. It's not too complicated. I will also say that this may drive your decision if you're doing something like a duty drawback strategy, or you might be interested in interest payments. Knowing how many of your entries have liquidated could be relevant to your ultimate decisions. Okay, to sum it all up, going to the Court of International Trade, probably faster. You're going to the front of the line. You're sort of in the set of people that are going to be definitely first to get into a claims process. You're probably giving up interest, and you're treating all of your entries in bulk. You're not separating them out to sort of optimize your strategy. Customs and Border Protection, slower, but more nuanced. You could separate out entries. You could be more nimble with duty drawback strategies. You might get interest if administrative protests are denied. So that's a more complicated analysis because you have to look at liquidation status, whether you can file PSCs, whether you can file protests and the like. I think that most importers are better served by CIT action now, and I'll get to why, but just briefly, because you want to be front of line. There's tariff reimposition coming, and you want to get your refunds faster. That's generally going to be the case for most people. Okay, so I talked about assessing contractual impacts. There are contractual clauses that importers may have entered into that obligate them to pay other parties if they receive a refund, like exporters. That means that when you're doing your budget forecasting and projection about how the refunds will impact your business, you shouldn't ignore potential netting out effects. If you get $1 million of IEEPA refund, but you're paying $400,000 of that to exporters, you're only getting $600,000 of refunds. So you really need to assess downstream obligations if you have contractual impacts. Okay, the replacement tariffs. So I do run this tariff tactics blog, and I think it was January 30th in our Jan 30th post, I outlined what we're likely to see. This is pretty much what I outlined and what is actually happening. These are the statutes where the president could reimpose tariffs. We've got Section 122. Unlike IEEPA, it very clearly authorizes the president to issue a tariff, but it has guardrails. It can only be up to 15%, and it can only be for 150 days, and it's only for certain conditions. Now we have Section 232, which allows the president to impose tariffs on national security grounds, but it requires Department of Commerce to investigate, and there needs to be some notice and comment and hearing and a report. It's generally sector specific. So an example I gave is minerals and mineral derivative products. It's sector specific because it's typically about national security and supply chains that are needed to protect national security interests. We've got 301 here, which I've litigated. It was a major pillar of the Trump administration's tariff imposition in the first Trump administration, specifically with respect to China. There were a lot of Section 301 China tariffs. It's country specific. It's similar to Section 232 in that it requires an agency investigation, notice, and hearing. But here we're talking about the United States Trade Representative, not Department of Commerce, and it's not restricted to national security. It's typically about unfair trade practices. Lastly, we have Section 338. It's never been used by any president since it was enacted as a Great Depression era statute. Theoretically, it authorizes the president to impose a 50% tariff on all imports from a specific country, specifically to combat some discriminatory trade practice. Nobody's ever done it, which means there's not a lot to go on as to how that would play out. But I suspect that this administration is looking into whether and how they could impose 338 tariffs. So here's a handy little chart that I made. These are, the first column is the types of tariffs. The second is the purpose, the at least notional purpose that needs to be invoked. The third is the scope. And with 122, I'll note, as written, it's supposed to be country specific, but the administration is implementing them essentially on a broad and global scale. With Section 338, we just don't really know. It's never been used, but reading the text of the Tariff Act of 1930, it looks like it should be country specific. With 122, there's no, you don't need to show any precondition for imposition. Again, it has guardrails, which is why it's unlike the other statutes. Its amount is up to 50%. It's temporary. The other ones are either an unlimited amount or, in the case of 338, 50%, and duration is not specified. Okay, right now we're dealing with 122. Everything else requires notice and comment and procedures that will take longer. So let's talk about 122. When the administration announced their 122 tariffs, they had two annexes to the proclamation. One says that the tariff will not hit goods, quote unquote, on the water and entered before, we're talking about entries here, February 28th. And there's some exemptions as well. That's in Annex 2. Exemptions are, products that are subject to other tariffs. There are free trade agreements. I noted one here that I'm not sure is super relevant because I wasn't sure who was showing up, but I think it's relevant to a lot of people, so I just threw this in. This is a Dominican Republic free trade agreement, and that is specifically marked products, textile apparel products that fall under that free trade agreement are exemptions to 122. This is like a broader point that should be raised, which is that when we read about these tariffs in the media or we hear about these tariffs, the devil's in the details, and your product may fall within an exemption, so it may actually be of less relevance to you. But I do think the big takeaway is think about exemptions, think about timing. There's been a lot of talk about whether 122 tariffs will ultimately be upheld. The reason is that the language is pretty narrow and seems to be country specific, though they have been imposed pretty globally. It's supposed to be to deal with large and serious balance of payments deficits, prevent an imminent significant depreciation of the dollar, cooperate with other countries. Now, in that chart, I said that there is no precondition, and I'll just say I don't know that these constraints are real constraints, and I don't think the administration is treating them as real constraints. So as a practical matter, there are no preconditions, but textually there are these three conditions. Now, if we apply our earlier 333 model to this, as opposed to the 6-3 model, we get a different and I think more accurate prediction. Three justices like the major questions approach, and under the major questions doctrine, imposing Section 122 tariffs outside of this statutory language might be found invalid because, again, the taxing and tariff power are core legislative powers, and this is like a non-delegation major questions issue. I do note Justice Barrett, kind of a question mark on that. Then we have our statutory construction justices. So that's a might, I would say is 2.5, maybe. Although I would point out Section 122 does clearly talk about tariffs, unlike IEEPA. We have our statutory constructionists. Insofar as Section 122 talks about tariffs, and they are less concerned with quote unquote major question or non-delegation, I think they could sustain a 122 tariff, even though they represent a sort of a liberal bloc. And then we have the dissent who will definitely sustain. So although a lot of people are saying, listen, we think these 122 things will be challenged, my reading is probably it's not going to work, maybe, but I think that it's a much more nuanced question. The last thing I'll say is the administration did argue in their oral arguments that they needed to use IEEPA because 122 tariffs and other similar tariffs were inapplicable. But, and some people have talked about that, that doesn't trigger estoppel because they didn't win on that point. They lost on the IEEPA case. If the court had upheld IEEPA adopting their argument, then yes, they would be estopped from then reimposing or imposing additional tariffs. But they're not estopped, and I don't know that this actually does more than maybe expose some inconsistency, but it's not legally relevant. So what I think will happen here is we've got these 122 tariffs, and then probably in a 6 to 8 month period, we're looking at these notice and comment tariffs, which means if you're an importer, you really should be monitoring the publications from the United States Trade Representative, Department of Commerce about notice and comment. I will tell you, having litigated these issues, agency actions are reviewable under the Administrative Procedure Act. And what you would think of as discovery in a normal case is just quote unquote the agency record, which includes the comments. So comments are relevant. They're part of what can be the record on litigation in the court. And, they are protective to some level of your interests. The timing issues are interesting to me because I suspect importers are just going to be facing tariffs pretty continuously. Section 122 tariffs go for 150 days, which is about 5 months. Congress can extend them, but I think it's unlikely given what we're seeing that Congress will. Notice and comment periods typically take more than 6 months. Section 232 provides the Department of Commerce up to 270 days to report to the president. But I think the administration is going to push the agencies to use faster processes. So we're likely going to see these 301 and 232 tariffs pretty close on the heels of the expiration of the 122 tariffs. And this is the real reason why you probably want to be first in line, given that the administration may be trying to use these new tariffs to fund payments of the IEEPA tariffs, and we can expect them to be fairly aggressive. Speed matters, I think, more than these more nuanced questions of do I get interest and how do I maximize my recovery. Okay, some helpful resources, me and our tariff tactics blog. And with that, I am done with the presentation.
Oh my goodness. Thank you so much. That was incredibly helpful. Very, very comprehensive. I appreciate that. So I have several questions and then we can open it up if others do as well.
Sure.
So first, I just want to be clear that I want to confirm very clearly that
Mhm.
there have to be refunds now at this point under this ruling because it has been the collection of these funds essentially was struck down the basis. So there has to be 100% there has to be a refund.
Yeah, I'm not going to give you the lawyer's answer first, but then I will give you the lawyer's answer. The answer is yes, there have to be refunds. Now I'll give you the lawyer's answer. Um, there's two questions here: timing, right? Delay. And when I was interviewed by Bloomberg Law and was quoted, I basically said there are many ways the administration can make this a very quote unquote labyrinthine process. So they can delay refunds, but they can't not refund. The second answer is more nuanced. I was speaking to somebody, and they said, well, that's great that they're supposed to do it, but what if they don't? And one thing I'll note about the Supreme Court decision is it does not order the federal government to create a refund process. They're waiting for the lower courts, for the Court of International Trade, to order the agency to refund. And without an order, they're theoretically supposed to do it, but nobody's telling them to do it. This is an enforcement problem. And, I think that the refunds will be processed because I think that as much as the administration doesn't like this ruling, it would be incredibly extraordinary, bordering on bizarrely unprecedented for an administrative agency like Customs and Border Protection to just outright ignore the judicial order. That being said, this particular client asked me, what if that happens? This is not the same administration as, the 1990s case you described. That was a different time. And to that question, I have no answer. I'm a lawyer. I deal with institutions that I assume will follow the rule at some level. If they utterly fail to follow the rule, there's not much we can do about it. So I don't want to stick my neck out and say it could never be the case that you don't get your refund. I just think that's not likely in any plausible scenario. What's more likely is delay.
Got it. Okay, that's very helpful. Um, and again, I know in your presentation you touched on contractual obligations, but I want to
Mhm.
go deeper into that because obviously tariffs have naturally rippled through the economy.
Sure,
So
sure.
when somebody imports something, they are the entity that actually pays the
Yeah,
tariff, but that of course is passed along. And so I
yeah.
wanted to see to what extent might a business who has a contract with the importer. So,
Mhm.
secondhand, to what extent do they have a claim for getting a refund or a partial refund?
It's a really good question. So to unpack that, we've been talking about importers, but there's a more technical term, the importer of record, which is the party that submits the paperwork and is actually liable if there are problems with the paperwork. I didn't really talk about False Claims Act issues because it's far afield, but it's something to think about. And I can get into that if you want. But anyway, there's an importer of record and they are entitled to the refund. But in reality, if you're the business that paid the tariff and maybe you just made your customs record the importer of record, there are ways to sort that out. That's not the question you're asking, but I wanted that distinction to be made. What you're asking is, I'm not the importer, but I have a contract with the importer that says if they get a refund, that I get a payment. The straightforward answer to your question is it's a breach of contract claim. So it's not a tariff issue, really. It is a contractual issue. I'll give you an example. If I'm a Chinese manufacturing company and I export to the United States and I see these tariffs hit, I might have negotiated with the importer that I won't raise my prices if we agree in advance that in the event of a refund, I will get, X% of that refund. That could be a contract we've entered into. Now, let's say the importer gets a refund and fails to pay me. I have a contractual claim against them. It's not really a claim, what I would call a tariff litigation claim, because I'm not suing the United States government. I'm not suing Customs and Border Protection. I'm not suing the United States Trade Representative. I'm not asking the Court of International Trade for any relief with respect to the tariff entries or these like government parties. I'm just mad that somebody who was supposed to pay me, rightfully so, didn't pay me. So I'm rightfully upset about it. I have contractual remedies, and that's the straightforward answer.
Mhm. And certainly in this environment, if people do not have that sort of clause in a contract, they probably should. But for those folks who don't, if their contract is silent on the issue altogether, um, under what circumstances might they have a claim? For example, if there was a specific tariff surcharge that they had to pay as a result of the tariffs, would that be easy for them to potentially get reimbursed?
So there has been talk about certain types of consumer class actions or other actions for parties that aren't really in these contractual spaces but have paid. The challenge with that is twofold. From the Court of International Trade's perspective, they don't have standing because they didn't pay the tariff in the sense of write the check to Customs and Border Protection. So they're not the proper claimant. So that's problem number one. Problem number two is, as I mentioned, these tariffs are stacked. So the same product could have 3 or 4 different tariffs, and you'd have to actually separate out the IEEPA component from the non-IEEPA component, which is tricky. But I do think there's an avenue for relief. I like to be a creative litigator, and I'll give you this answer. Let's say you're a business that paid a tariff surcharge, and you now know that the counterparty was fully compensated. Depending on how your contracts were written, there may be unjust enrichment claims. There may be some kind of restitution claim. I don't think that that could possibly be a Court of International Trade issue, though, because their jurisdiction is limited to sort of the issues that I was talking about. That would be like your typical commercial litigation. You go to court and say they were unjustly enriched. I paid them and I shouldn't have because they've been compensated. I don't know how that's going to play out. This is part of what when Justice Kavanaugh referenced the refunds are going to be a mess. She was quoting the oral argument. I mean, that's part of what we're talking about. There are a lot of downstream actors here that have complicated situations.
Do you think that those people should be uh, asking on the record, how the importer of record plans to handle their potential refunds, or does it matter the
Yes.
timing for that?
Short answer, very much yes. And longer answer, that's your person you're dealing with. You're not dealing with Customs and Border Protection. You're not dealing with the president. You're dealing with a company that you say owes you money. So absolutely, your claims will be best addressed to them. And listen, I understand that as a business litigator, that there are theoretical answers and there's business answers. Maybe there's an existing business relationship that everyone wants to keep running smoothly. And maybe even though the importer might not legally feel that they're absolutely required to refund a tariff surcharge, they might just to keep the relationship happy. So there are many ways that these things could be resolved without sort of a strict claims and element analysis.
It's great. Um, so what about other types of relief? This has been a very this policy, the tariff policy, has caused a lot of damage in New
Mhm.
York City. And I don't know if you've seen, but we in Q2 of 2025, we actually had a lot of business closures, much more than we'd had probably in 5 years. Um, and some of that is probably due to the tariff impact. And so I just don't know to what extent uh, is there a claim for hardship relief for the pain that this has caused for some businesses.
It's a great question. You're talking about harm and we're talking about remedies, right? And we all know that
Correct.
harm can exist without remedies. That's just the law is never perfectly symmetrical. This is maybe one of those cases. Now, I mean, I don't want to speak out of turn or speak in broad terms of sort of political theory, but essentially, if enough people are unhappy about it, democratic pressure, and I don't mean political, Democrat, Republican, just political voting pressure could cause the administration to make some sort of effort to cut checks to people, to sort of remedy tariff harm, which they have talked about. I mean, President Trump has talked about cutting checks to people out of tariff revenue. That is a very rough and not very like sort of that solution is maybe helpful, but it doesn't really match the problem. That's why I say it's rough. It's sort of a rough remedy. Just give everybody money. From a claims perspective, we're talking about litigation. Obviously, you need standing, and you need an entity that you can sue or a person that you can sue. And it's really hard for me sitting here today to, without knowing, like every fact pattern will be so different, be hard for me to make a broad statement that these businesses have a remedy. Um, I'll give you a different example, and we are sort of dealing with counterfactuals and speculation here, but let's assume the administration were to implement a tax policy that raised taxes on certain businesses, and ultimately there was a challenge and it was found to be unconstitutional for some reason, and refunds were processed. If businesses closed during that time, I don't know that they're entitled to more than the money, is unfortunately the answer. If there were downstream effects of business closing, because like your local, service provider or vendor or supply chain person shut down, which caused you to have to reroute your supply chains, which then caused another downstream effect, which then made a consumer have to pay more. Those are very real impacts, but they're probably not going to be captured by the litigation system, which deals with standing and parties and, can only deal with sort of like first order problems. Sorry, it's not a great answer, but it's my best answer.
It's one of the top questions we're getting right now, so thank you for that. Daniel, it sounds like you have a question.
Yeah, thanks for the opportunity to speak. And then thank you for the presentation. It was very informative. Appreciate that.
Glad to hear.
For a background, I'm a CPA, so I don't have a fraction of your understanding of this. But there are some questions I had. One, I'm sure is right in your wheelhouse, and you'll know the answer to that right away. The second relates to some investing activities that have occurred related to this. First question I had was the IEEPA the only tariff that was being challenged?
Yes.
Oh, okay. Okay. And the other question I had was there was activity in the market where people were buying tariff claims. PE was buying tariff claims. And I was curious if the activity on that has increased or decreased as a result of the ruling, if the amount that the claimants are entitled to has moved upwards or downwards as a result of this. And also, I was wondering if you had any thoughts on the prudency of entering such a relationship if it could mean getting, 40, 50% right now rather than waiting. Sorry for the lengthy question.
No, this is such a good question. I'm really glad you asked this question. And I will just tell you, before I was a lawyer, I was a math major and I briefly was a finance guy. So I'm not afraid of um, uh, talking about numbers or even talking about what we're really talking about is turning a claim into like an instrument, like a financial instrument. So let's unpack that. There are judgment marketplaces, setting aside tariffs, where if you have a judgment, you can sell your judgment. And people will buy the judgment. The law recognizes the ability to assign claims. It's not quite the same as saying I'm going to write a check to you, but it's kind of like that. It's an instrument that can be assigned. And I'm being a little bit vague here because there are a lot of situations where you cannot assign claims. But let's just say, as a general statement, you can assign claims. The way judgment marketplaces typically work is they will look at a claim and think about how collectible is this? Is the person that owes the money actually a person who can pay and who reasonably can be forced to pay? How long has this judgment been out there and unpaid? They're trying to assess like the risk profile in the judgment. A similar thing is, I think, happening in the IEEPA claims space, which is that before the Supreme Court ruling, there was obviously some uncertainty. It was possible that the court would uphold the tariffs. And I think my 3-3-3 chart shows that it was actually more possible than people realized. It wasn't such a clean 6-3 split. So I would think the markets would have priced that uncertainty into these claims. But now that the Supreme Court has ruled, the uncertainty is not so much about whether the IEEPA tariffs were valid. The uncertainty is about how long will it take to get refunds. And that's a very different question. If I'm going to buy an asset and it's going to pay me out tomorrow, I'll pay more for it than if it pays me out in 5 years, but I'm still going to pay something for it. So, I mean, my answer to your question, I know that there's a marketplace out there on this. I haven't actually followed it very carefully. I would suspect that after the Supreme Court decision, these claims became more valuable. And so I would suspect that it impacted claims transferring markets, but I don't know whether it increased the amount of claims because all it would have done was increase the value of the claims. That doesn't necessarily mean more people would buy it. It's frankly maybe more expensive now to buy an IEEPA claim. It doesn't mean more people would sell it. Maybe now if you have an IEEPA claim and you're feeling better about the fact that you're going to get money, you don't want to sell it. But to answer your last question, which is it advisable? I mean, obviously I'm not your lawyer, so don't want to give you that advice. I'm going to speak very generally. It's something people do, and it depends on their specific situation. A lot of times it's just a trade-off between do I want money now or later. There are meritorious cases that people drop because they think that the spending on the legal side is impacting too much their other business priorities. It doesn't mean that they think the case is bad. They just drop the case. So there's all sorts of decisions that businesses might make around, do I want this money now? Do I want to wait for the refund process later? And they have nothing to do with whether the refund is owed. And that's maybe my best answer to you, which is you probably are a better judge being a CPA about that, asset value calculation than frankly than I am. But yeah, definitely it changes the picture for those claims.
Well, thank you for your insight.
Thank you. So, a long story short, what I'm hearing, and you're going to clean it up, what I'm hearing is that folks should really try to think about filing a claim now so that they are at the front of the line when the refund process is unveiled.
Correct.
Love it. Okay.
Yeah. And I do want to clarify, I'm saying this now, but I was not saying this before. This is not you don't have to hire me. You don't have to work with me. You can hire anybody who knows how to do this, but I do think now is the time to file.
Fantastic. Well, thank you so much, Siddartha Rao, and thanks to everybody for joining us. Let us know if you need any help. Nadia put the information in the chat. You can reach out to our help desk, which is at our website, manhattancc.org. Thank you so much.
And thank you so much for having me.